Welcome to the deep dive. Today, we're really jumping into something huge, the actual blueprint of how India is governed its constitution.
Right, the foundational rules.
Exactly, and forget dusty old legal texts, right? We mean the living rules shaping everything from, say, how a local district judge is appointed.
To that really intricate dance of power, between the national government and the states, often quite a dance.
Yes. So, you've given us this amazing stack of material, the actual constitutional articles, legal takes, those landmark Supreme Court rulings, and our mission. Basically, unlock the key stuff, give you those aha moments, and, shortcut your way to being deeply informed without getting bogged down.
That's the plan. This isn't just reading out articles. It's about understanding the thinking behind India's system, how it's meticulously crafted to try and ensure judicial independence right down to the local level, and how it empowers local bodies and tries to maintain that delicate, sometimes tested balance of powers in such a vast, diverse nation. We'll be digging into the specific articles that make these big ideas real.
So if you've ever found yourself wondering about the real nuts and bolts of judicial appointments, or, why Delhi's setup is always in the news,
Delhi's always a flashpoint.
or the surprising power of your local panchayats, or how parliament can sometimes, quite dramatically actually, step into a state's legislative territory.
Well, you're absolutely in the right place. Let's unpack this blueprint, right? Part one. We're kicking off our deep dive looking at the very grassroots of India's judicial system, the subordinate courts. These are the courts most people actually interact with day to day, the ones delivering justice, hopefully, right to their doorsteps. And for that justice to mean anything, their independence is absolutely crucial, isn't it? But how do you actually ensure that all the way down there? That's an excellent place to start. And it really reveals, I think, a profound foresight from the Constitution's framers. Chapter 6, Articles 233 to 237 specifically, lays out this quite intricate framework. It's a testament to their understanding that real judicial independence isn't just about the big courts, the Supreme Court or high courts. It has to be guaranteed at the very lowest rungs, where people first encounter the justice system. This setup is fundamentally designed to insulate every local judge from, potential political or executive pressure. Arm twisting, you could say.
Okay, so let's start right at the beginning then. How do these vital local judges, specifically that are district judges, actually get appointed? How are they brought into the system?
That's Article 233, Appointment of District Judges. The core idea here is that the power to appoint, post, and promote district judges rests with the state governor. But, and this is absolutely the crucial bit, it's far from being just the governor's unilateral decision. Clause 1 of 233 clearly says these actions shall be made by the governor in consultation with the High Court exercising jurisdiction in relation to such state.
In consultation. So it's not just the governor's call then. The High Court's voice is absolutely critical. Sounds like they act as a powerful gatekeeper of sorts.
Precisely. That word consultation isn't just a formality, like, politely asking for an opinion you can then ignore. The Supreme Court has consistently interpreted it as effective and meaningful consultation.
Effective and meaningful. What does that translate to in practice?
It means the High Court's recommendation carries such substantial weight that the governor generally cannot disregard it without very strong, judicially sustainable reasons. It's almost binding, in effect. And for direct appointments, people coming straight from the bar, Clause 2 adds another layer. A person not already in judicial service needs at least 7 years as an advocate or pleader, and they must be recommended by the High Court. So it's a dual requirement, practical legal experience plus judicial approval from within the system itself.
That is a strong mechanism for independence. What's the underlying thinking, the rationale for giving the High Court such a pivotal role here? Why not, say, a civil service board or the executive directly making the call?
Well, the primary object, the stated goal, is explicitly to ensure the independence of the subordinate judiciary from executive interference. That's paramount. The High Court, being the highest judicial authority in the state, is considered the body best equipped to assess suitability, competence, judicial temperament, integrity, all those crucial factors.
Right, they know the system, they know the people, ideally.
Exactly. It's fundamentally about preventing appointments from being swayed by political favoritism or administrative convenience. You mentioned a landmark case earlier in the outline, Chandra Mohan v. State of UP from 1966.
Yes, that one seemed important.
It absolutely was. The Supreme Court famously struck down state rules that tried to dilute the High Court's role by bringing executive officers into the selection committee. That case became a cornerstone, emphatically reinforcing that consultation under Article 233 means consultation with the entire High Court, effectively, and without any executive dilution. And later, State of Bihar versus Bal Mukund Saw in 2000 reaffirmed that state legislatures also can't encroach on this high court consultation power. It's fundamental. This is all part of what we call the doctrine of effective consultation, and it deeply embeds judicial independence right from the appointment stage.
Okay, that makes a lot of sense, ensuring quality and independence right from the start. But what happens if, maybe historically, some appointments weren't made perfectly according to these really strict rules? Did the system ever face a kind of crisis because of that?
It's a fascinating historical point, actually, and a great example of the Constitution needing to adapt to, well, unforeseen practical realities. This brings us neatly to Article 233A, validation of appointments of district judges. This article was inserted by the 20th Amendment in 1966, and crucially, it acted retrospectively.
Ah, retrospectively, meaning it applied backwards to things that had already happened. So those strict Supreme Court interpretations, like in Chandra Mohan you mentioned, must have suddenly shown up some older irregularities. This sounds like a constitutional cleanup operation.
That's a perfect way to put it, a cleanup or damage control.
Yeah.
Exactly. The strict readings in cases like Chandra Mohan suddenly highlighted past practices for appointing district judges that were, frankly, not quite in line with the spirit or even the letter of Articles 233 and 235. And this created a huge potential problem. It threatened to invalidate potentially numerous appointments made under those older, looser practices,
Which would mean?
which by extension threatened thousands of judgments delivered by those very judges. Imagine the chaos, the legal uncertainty that would unleash.
Right, a complete systemic meltdown.
Precisely. So Article 233A was a very pragmatic, a very necessary one-time fix. It functioned as a constitutional validation clause specifically designed to cure those particular defects in past appointments made before 1966 and thus prevent that systemic breakdown, ensuring judicial continuity. Its scope was limited, though. It cured only defects related to noncompliance with 233 or 235, not other potential flaws. It's a powerful demonstration of the doctrine of validation of the Constitution itself, stepping in to retroactively legitimize certain actions to avert a much larger crisis.
That really shows the Constitution isn't just static, it can adapt. Okay, so we've covered district judges pretty thoroughly. But what about all the other judges at the lower levels? Civil judges, magistrates, the entry-level folks. How do they get into the judicial service?
That's where Article 234 comes in. Recruitment of persons other than district judges. This article specifically deals with recruitment for positions below the district judge level, your entry-level judicial officers. The core concept here is that appointments are made by the governor, yes, but strictly in accordance with rules made by him, after consultation with the State Public Service Commission, SPSC, and with the High Court. So notice that crucial dual consultation requirement for these grassroots judicial roles.
Both the SPSC and the High Court. That seems like a very belt and braces approach for entry-level jobs. Why involve two separate bodies? One focused on general civil service recruitment, the other on the judiciary itself.
It's designed for maximum impartiality and also to ensure suitability for the specific demands of a judicial role. The SPSC's involvement guarantees a standardized, competitive examination process ensuring fairness, transparency, and merit-based selection, just like for other civil services.
Okay, the merit part.
Exactly. But the High Court's input is equally vital, perhaps even more so, for assessing judicial aptitude. That means understanding the specific qualities, the right temperament, the legal acumen needed for a judicial role, which might be different from purely administrative roles. So, for instance, the High Court is often heavily involved in setting the syllabus for the judicial exams, evaluating the papers, and crucially, conducting the interviews to really gauge that judicial temperament. Landmark cases like State of Bihar versus Bal Mukund Saw again, and the All India Judges Association cases from the early 90s have consistently underlined this mandatory dual consultation. They reinforce the need to strengthen the subordinate judiciary through proper, meritocratic, and independent recruitment right from the start. This upholds both the independence of the subordinate judiciary and the principle of merit-based recruitment.
Right, so they're appointed through this careful process. But once they're in the job, who actually runs the show day to day? Who manages their careers, transfers, promotions, making sure they're performing well? Where does that daily oversight and control come from?
This is, arguably, one of the most powerful provisions for safeguarding judicial independence at the lower levels. Article 235, control over subordinate courts. Its core concept is absolutely clear. Comprehensive control over district courts and all subordinate courts is vested exclusively in the High Court. And control here isn't just some vague oversight. It explicitly includes fundamental aspects like posting judges, promoting them, granting leave for officers below the district judge level. Crucially, the Supreme Court has interpreted this to implicitly extend to disciplinary matters for all subordinate judges, including district judges. Even though the formal order of appointment or dismissal of a district judge might technically rest with the governor, the initiation and recommendation for disciplinary action comes from the High Court.
Wow. Comprehensive control vested exclusively in the High Court. That sounds incredibly powerful. Does this mean the High Court can just, do whatever it wants with these judges without any checks?
It is indeed very powerful, designed to be a strong shield. But not entirely unchecked. The Supreme Court case State of West Bengal versus Indrapendra Naik Bakshi back in 1966 was pivotal here. It declared that control under Article 235 was comprehensive, specifically including disciplinary jurisdiction. This judgment clarified that the High Court alone has the authority to initiate disciplinary proceedings and recommend or impose punishment.
Acting as their shield against executive interference, essentially.
Exactly. Think of the High Court as the primary protector and manager of the judicial family within the state. It insulates them from external pressures in their day-to-day functioning, their career progression, and discipline. However, and this is the important limitation, the High Court must still act in accordance with existing service rules applicable to those judicial officers. And those officers retain their rights of appeal under those rules. So it balances powerful oversight with individual procedural protections, ensuring fairness even within the system. Another case, Registrar Administration, High Court of Orissa versus Sisar Kandasatapathy, 1999, further emphasized this exclusive and complete control, subject only to the initial recruitment process and the governor's formal role in appointing dismissing district judges based on High Court recommendations. This firmly embeds the principle of independence of the judiciary at all levels and establishes a clear system of hierarchical judicial control.
Okay, before we move on from this really critical chapter on the judiciary's foundations, the Constitution often defines its terms very precisely, doesn't it? To avoid any confusion, what terms does it clarify specifically for this section on subordinate courts?
Yes, definitions are crucial. That's Article 236. Interpretation. It provides essential definitions specifically for Chapter 6. Its core purpose is to define district judge and judicial service to make sure everyone understands exactly who and what these protective articles apply to. Clause A gives an inclusive definition of district judge. It's not just one title. It covers a wide range of senior judicial posts: city civil court judge, additional district judge, sessions judge, chief presidency magistrate, and others.
So making sure the protective umbrella of Article 233 covers all these key senior roles.
Precisely. It ensures those safeguards aren't narrowly confined. Then Clause B defines judicial service as exclusively consisting of persons intended to fill the post of district judge and other civil judicial posts inferior to the post of district judge. This clearly distinguishes judicial roles from purely administrative or executive ones, preventing any blurring of lines or executive encroachment into judicial functions.
So it's all about clarity, ensuring the protection applies correctly and reinforcing that fundamental separation between the judiciary and the executive.
Exactly right. It underpins definitional clarity and constitutional interpretation and strengthens the practical application of the separation of judiciary from executive by clearly marking out the judicial cadre. It's about building that robust, self-contained, and independent judicial branch from the ground up.
Okay, so the core judicial service is very thoroughly covered by these articles, but what about magistrates? Sometimes, historically, didn't they have a slightly different structure, maybe even falling under executive control in some ways? Does the Constitution provide a way to bring them fully into this independent judicial fold?
Absolutely. And this shows the Constitution's forward-looking approach. Article 237, application to certain classes of magistrates, provides exactly that, a progressive mechanism. Its core concept is straightforward. The governor can, by public notification, direct that the provisions of this chapter and any rules made under it shall apply to any class or classes of magistrates in the state. They can do this with specified exceptions or modifications, tailoring it as needed.
So, essentially, magistrates who might have previously been under some form of executive oversight could be gradually brought under the High Court's control and integrated into the main judicial service structure.
Precisely. That's the nature and object of Article 237. It's designed to facilitate the gradual integration of all functionaries performing judicial duties into the mainstream judicial service. This strengthens their independence and, importantly, helps fulfill that fundamental directive principle of state policy in Article 50, which mandates the separation of judiciary from executive. The Chandra Mohan case, which we've touched on a few times, really underscored this grand constitutional scheme of separation, and Article 237 acts as a key practical tool for achieving this progressive realization of constitutional goals over time, bringing everyone performing judicial functions under the judiciary's umbrella.
Wow, okay. That's an incredibly thorough look at the courts. It really highlights the meticulous, almost layered efforts to ensure judicial independence at every single level, from how judges are pointed right through to their day-to-day control and even integrating historically separate roles. Now, let's totally shift gears. From the judiciary, let's look at governance structures themselves, starting with a unique and often fascinating part of India, the Union Territories. These aren't quite states, are they? They operate differently.
No, they're distinct. Union territories, or UTs, operate under a different administrative model, primarily under the central government's authority. Part 8 of the Constitution, Articles 239 to 242, lays out this unique arrangement. Article 239 is the foundational piece here. It establishes that UTs are generally administered directly by the President, who acts through an administrator appointed by the President. However, Parliament always has the power to make laws to alter this structure. And interestingly, the governor of an adjoining state can also be appointed as the administrator of a UT. When they do that, though, they act in their capacity as administrator independently of their own state's council of ministers.
So the default is direct control from the top, from the president via an administrator, but Parliament holds the key to create variations or exceptions to that rule.
Exactly. And that flexibility Parliament has leads to some quite fascinating variations in how different UTs are governed. For instance, take Article 239A. This allows Parliament to create local legislatures or councils of ministers, or even both for certain union territories, like Puducherry. This grants them a significant degree of self-governance, moving them a step away from direct presidential rule and giving local populations a stronger democratic voice. And critically, any law Parliament makes to create these bodies is not considered a constitutional amendment under Article 368.
That makes it much easier to set up or modify these structures, doesn't it? No need for that supermajority state ratification process.
Precisely. It allows for more flexibility in tailoring governance structures for UTs without the rigidity of amending the Constitution itself.
And then there's Delhi. Its unique governance structure seems to be perpetually in the news, often sparking political debates, legal challenges, the works. What makes Delhi so special and, frankly, so often contentious?
Delhi is truly unique, constitutionally speaking. It's designated as the National Capital Territory, NCT, by the 69th Amendment, which inserted Article 239AA back in 1991. It's effectively a union territory, yes, but it has its own legislative assembly and a council of ministers, giving it that state-like appearance. However, and these are the significant, often contentious limitations the administrators called the Lieutenant Governor, LG. And while the Assembly can make laws on most state list and concurrent list matters, there are 3 crucial exceptions: public order, police, and land. These vital subjects remain firmly under the central government's control, exercised through the LG. Furthermore, Parliament retains the power to legislate on any matter for the NCT, even those the Assembly can legislate on. And if there's a conflict or repugnancy, Parliament's law always prevails.
Okay, so it has this state-like feel. People elect their local government, their MLAs, they have a chief minister. But these absolutely vital subjects, police, maintaining order, land use, are kept firmly under central control. And the president also seems to have a powerful role, even with the Council of Ministers. This seems designed for friction.
Absolutely. That structure inherently creates a persistent dynamic tension. It reflects Delhi's unique dual status. It's both a local territory with its own population needing governance, and it's the national capital, the seat of the union government. The chief minister is appointed by the president, and the other ministers are appointed by the president on the CM's advice. But crucially, they hold office during the pleasure of the president.
During the pleasure of the president, that sounds quite powerful.
It is. This inherent constitutional design, this sort of shared sovereignty or dual control, inevitably leads to frequent administrative and political disagreements, and often high-profile legal battles. It ensures a strong central hand in governing the capital while simultaneously attempting to accommodate local democratic aspirations.
And what happens if that unique machinery in Delhi breaks down? Is there a mechanism similar to precedent's rule in states?
Yes, there is. Article 239AB covers that. Provision in case of failure of constitutional machinery. Similar to Article 356 for states, the president can suspend the operation of Delhi's governance provisions under Article 239AA if satisfied that a situation has arisen where the administration cannot be carried on in accordance with those provisions. This could be based on a report from the LG or otherwise. It's a critical safeguard against prolonged administrative deadlock. Then we have Article 239b, which deals with the administrator's power to promulgate ordinances specifically mentioned for Puducherry, but applicable to Delhi too. This allows the LG to issue ordinances when the assembly is not in session, much like the president or governors can. But there's an extra check. The administrator can only do so after obtaining specific instructions from the president.
So quite a significant layer of central oversight persists, even for union territories that have their own elected legislative bodies. What about the president's general power to make laws directly for those other UTs, the ones without a legislature?
That's covered by Article 240, and it's quite broad. The president can make regulations for the peace, progress, and good government of specific UTs, currently listed as Andaman and Nicobar Islands, like Shadweep, Dadra and Nagar Haveli, and Daman and Diu, and Puducherry. What's particularly interesting here is the power these regulations hold. They can even repeal or amend acts of parliament that might otherwise apply to these union territories. That's significant power.
Wow, presidential regulations overriding parliamentary acts in specific UTs.
Indeed. However, for Puducherry, this power of the president to make regulations is suspended while its legislature is functioning. It revives only if the legislature is dissolved or suspended. Finally, Article 241 ensures access to higher judiciary for UTs. It allows Parliament to establish a high court for a union territory, or declare an existing court as a high court for it, or simply extend the jurisdiction of an existing state high court to cover UT. And just for completeness, Article 242, which related to Coorg, was repealed way back by the Seventh Amendment in 1956, so it's just a historical note now.
Okay, that covers the UTs. Now, from that sort of central administration, let's zoom right down to the most local level, to the very heart of rural India. What about rural self-governance? How does the Constitution empower communities right there in the villages?
That brings us to Part 9, titled simply The Panchayats. This was a truly revolutionary addition to the Constitution, inserted by the 73rd Amendment in 1992. These articles provide this solid constitutional backing for democratic decentralization. It represents a monumental step towards realizing Mahatma Gandhi's vision of Gram Swaraj, empowering millions at the grassroots level. It basically transformed a directive principle into a justiciable, enforceable part of the Constitution.
Panchayats, yes. They're often called the bedrock of local self-governance in rural India. What does the Constitution actually say about their fundamental structure, their powers? How are they meant to function?
It's quite detailed, and deliberately so, to ensure they're not just symbolic bodies, but have real functions and powers. Article 243 starts with crucial definitions, clarifying key terms. Gram Sabha, for instance, is defined as the body consisting of all persons registered in the electoral rolls relating to a village comprised within the area of a panchayat at the village level. It's the foundation.
So the Gram Sabha is basically all the voters in the village.
Essentially, yes, the collective body of citizens. Article 243A then empowers the Gram Sabha, stating it can exercise powers and perform functions at the village level as the state legislature may provide by law. It's the foundational democratic unit. Then Article 243B mandates a three-tier system of panchayats in every state. Panchayats at the village, intermediate, like block or taluk, and district levels. There's an exception, though, providing flexibility. Smaller states with a population not exceeding 20 lakhs, 2 million, are allowed to not have panchayats at the intermediate level. This ensures the structure is adaptable based on population size and administrative feasibility.
Okay, a three-tier structure generally. And how are these panchayats actually composed at each level? How do people get onto these bodies? Elected, nominated.
Article 243C deals with composition. The crucial point is that all seats in a panchayat at all levels are filled by direct election from territorial constituencies, often called wards, within the panchayat area. This ensures direct accountability to the local people. State legislatures can also make laws to provide for the representation of the chairpersons of the village panchayats in the intermediate panchayats and chairpersons of the intermediate panchayats in the district panchayats. They can also provide for the representation of MPs, MLAs, and even MLCs representing constituencies that fall within a panchayat area at the intermediate or district levels. Importantly, the chairpersons of the intermediate and district level panchayats are elected by and from amongst the elected members thereof.
Now, reservations. We know they exist for parliament and state assemblies. Are they also mandated right down at this local panchayat level?
Absolutely, and this is a very significant feature. Article 243D mandates these reservations quite comprehensively. Seats must be reserved for scheduled castes, SCs, and scheduled tribes, STs in every panchayat, and the number of reserved seats must be proportionate to their population in that panchayat area. Furthermore, and this was truly groundbreaking, not less than one-third of the total number of seats reserved for SCs and STs must be reserved for women belonging to those communities. And overall, not less than one-third of the total number of seats to be filled by direct election in every panchayat, including the seats reserved for SC Sonia's women, must be reserved for women. This reservation also applies to the offices of chairpersons.
Wow. So reservations aren't just an afterthought here. They're deeply woven into the fabric of local governance. Mandatory reservations for SCs, STs, and women, including for leadership positions. That's a powerful commitment to representation, isn't it? Especially for women in rural areas.
It's a monumental step. It ensures that marginalized communities and women, who might otherwise be excluded, have a guaranteed voice and a tangible role in local decision-making. It directly addresses historical imbalances and promotes far more inclusive governance at the very grassroots. Additionally, Article 243D allows state legislatures to make provisions for reserving seats or chairperson posts for backward classes as well, giving states flexibility based on their specific demographic context.
And what about their term? Are these elected bodies stable, or can they be dismissed easily by the state government?
Stability is key. Article 243E provides for a fixed 5-year term for every panchayat, starting from the date appointed for its first meeting. It can be dissolved earlier under state law, but if it is, elections to constitute a new panchayat must be completed before the expiry of its original term, or within 6 months from the date of its dissolution, whichever is earlier. There's a small rider. If the remaining period of the dissolved panchayat is less than 6 months, it's not necessary to hold an election for that short period. This provides crucial stability and continuity. Article 243F then deals with disqualifications for membership, generally linking them to disqualifications for the state legislature, but with one key difference. The minimum age for panchayat membership is set at 21 years, not 25.
Lowering the age bar to 21, that potentially allows younger leaders from the community to emerge and participate.
Exactly. It encourages youth participation in local governance.
Okay, so they're constituted through elections with reservations. They have a fixed term. But what powers do these local bodies actually wield? What can they do for their communities? Is it just about basic civic amenities or more?
It's potentially much more. Article 243G is central here. It endows panchayats with such powers and authority as may be necessary to enable them to function as genuine institutions of self-government. This includes the power and responsibility to prepare plans for economic development and social justice, and critically, to implement schemes related to these goals. Specifically, the article mentions implementing schemes covering matters listed in the 11th schedule of the Constitution.
The 11th schedule. What kinds of things are in there?
It's a substantial list, covering 29 items directly relevant to rural life. Think agriculture, land improvement, minor irrigation, water management, animal husbandry, fisheries, social forestry, small-scale industries, rural housing, drinking water, roads, culverts, rural electrification, poverty alleviation programs, education including primary and secondary schools, health and sanitation, family welfare, women and child development, social welfare, public distribution system. The list goes on.
That's incredibly broad. These aren't just trivial matters. They're the absolute lifeblood issues for rural communities.
Precisely. The Constitution empowers panchayats to potentially manage or influence all these crucial areas. Now, how much power they actually get devolved depends on the state legislature, but the constitutional framework is there. And to make this meaningful, you need resources. So Article 243H deals with powers to impose taxes by and funds of the panchayats. It authorizes state legislatures to empower panchayats to levy, collect, and appropriate specific taxes, duties, tolls, and fees. It also allows states to assign certain state-collected taxes to panchayats, provide grants and aid from the state's consolidated fund, and mandates the creation of dedicated panchayat funds to credit all their money. Financial autonomy, or at least financial capacity, is absolutely crucial for their effective functioning and genuine independence.
A serious attempt to make them functional and financially viable, not just dependent on handouts. But who oversees their finances? Is there a mechanism to ensure fair distribution of funds from the state and proper management?
Yes, a very important institutional check is built in. Article 243I mandates the constitution of a state finance commission by the governor every 5 years. This commission plays a vital role. Its job is to review the financial position of the panchayats and make recommendations to the governor about 1. The principles governing the distribution of state taxes between the state and the panchayats. 2. Determining which taxes, duties, tolls, and fees may be assigned to or appropriated by the panchayats. 3. The grants and aid to be given to the panchayats from the state's fund. And 4. measures needed to improve the overall financial position of the panchayats. Article 243J further allows the state legislature to make provisions for the maintenance and audit of panchayat accounts, ensuring financial accountability and transparency.
So a dedicated body reviewing finances every 5 years. And what about elections? We have the Election Commission of India for national and state polls. Is there a similar independent body for these local panchayat elections?
Indeed, there is, mirroring the national structure. Article 243K establishes a dedicated state election commission for each state. It consists of a state election commissioner appointed by the governor. This commission is vested with the superintendence, direction, and control of the preparation of electoral rolls and the conduct of all elections to the panchayats. And crucially, to safeguard its independence, the state election commissioner can only be removed from office in the same manner and on the same grounds as a judge of a high court.
That's a very high bar for removal, ensuring they can act independently without fear or favor.
Exactly. It's designed to ensure free and fair elections at the local level. Article 243L then simply extends these panchayat provisions to union territories, allowing the president to specify any necessary exceptions or modifications.
Given India's immense diversity, are there any areas where these panchayat rules don't apply, perhaps due to unique historical or cultural reasons?
Yes, the Constitution recognizes that a uniform structure might not fit everywhere. Article 243M specifies certain exclusions. It explicitly states that Part 9, the Panchayat provisions, does not apply to the scheduled areas referred to in Article 244 and the tribal areas in Article 242. These areas have their own special governance frameworks under the 5th and 6th schedules respectively. It also excludes certain hill areas in Manipur for which district councils exist and the area covered by the Darjeeling Gorkha Hill Council in West Bengal. Interestingly, it also states that the provision for reservation of seats for scheduled castes under Article 243D shall not apply to the state of Arunachal Pradesh, reflecting its unique demographic makeup, which is predominantly tribal with negligible ST population. However, Parliament retains the power to extend the panchayat provisions to these excluded scheduled and tribal areas by law, subject to any exceptions and modifications it deems necessary.
Article 240N provides a transition period, stating that existing state laws relating to panchayats that are inconsistent with Part 9 would continue for 1 year from the commencement of the 73rd Amendment or until amended or repealed by the state legislature, whichever is earlier. Finally, Article 243 all places a significant bar to interference by courts in electoral matters concerning panchayats.
What does that mean exactly? No court challenges at all.
Not quite no challenges, but it channels them. It says that the validity of any law relating to the delimitation of constituencies or the allotment of seats cannot be questioned in any court. And, crucially, no election to any panchayat can be called into question except by an election petition presented to a specific authority prescribed by state law. This prevents elections from being constantly stalled or disrupted by court cases during the process, directing disputes to a specific post-election remedy.
Okay, that streamlines things. So that's an incredibly detailed framework for rural self-governance, truly aiming to empower the grassroots. But what about our cities, our bustling urban centers, towns, metropolitan areas? How does the Constitution address local self-governance there?
That's where Part IXA, titled the Municipalities, comes into play. It was introduced right alongside the Panchayat provisions by the 74th Amendment, also in 1992. It essentially mirrors the Panchayat framework in many ways, but adapts it for urban local bodies, recognizing their distinct needs, populations, and administrative complexities. It extends that same principle of robust local self-governance to urban India.
So the urban equivalent of panchayats, how are municipalities structured? Does it depend on the size and character of the urban area?
Yes, it does. Article 243P starts with definitions relevant to urban areas, including defining a metropolitan area, an area having a population of 10 lakhs, 1 million or more municipal area, and municipality itself. Then Article 243Q mandates the constitution of 3 distinct types of municipalities based on the size and character of the urban area. First, a Nagar Panchayat for a transitional area basically, an area evolving from rural to urban. Second, a municipal council for a smaller urban area. And third, a municipal corporation for a larger urban area. The criteria like population density, revenue, economic importance for classifying these areas are determined by the governor based on state law. Article 240Q also includes an interesting provision allowing the governor to declare certain areas as industrial townships based on their size and the municipal services provided by industrial establishments there. Such areas might then be excluded from having a regular municipality constituted for them, acknowledging their unique industrial nature.
Okay, three main types based on urban character. And how are these urban bodies composed? Is it also direct election? And do they have the same strong commitment to reservations that we saw for panchayats?
Yes, the principles are very similar. Article 243R states that all seats in a municipality shall be filled by direct election from territorial constituencies known as wards within the municipal area. Again, direct accountability to the urban residents. State legislatures can also provide for the representation of persons having special knowledge or experience in municipal administration, though typically without voting rights, and for legislators like MPs, MLAs, MLCs whose constituencies fall partly or wholly within the municipal area. Article 243S introduces wards committees. It mandates their constitution within the territorial area of a municipality having a population of 3 lakhs, 300,000 or more. These committees, consisting of one or more wards, are designed to bring governance even closer to the people in larger cities. The state legislature decides their composition and territorial area. And yes, the reservation policy is mirrored in Article 243T. It mandates reservation of seats for SCs and STs proportionate to their population in the municipal area. It also mandates that not less than 1/3 of the total number of seats be reserved for women, including the seats reserved for SC/ST women. And this reservation principle extends to the offices of chairpersons of municipalities as well. Similar to panchayats, state legislatures may also make provisions for reservations for backward classes. So that commitment to inclusion is firmly embedded in urban local governance too.
Right, so the structure and representation are parallel. I assume things like fixed terms, financial oversight, and election commissions also follow a similar pattern.
Yes, the framework maintains that consistency, adapting it slightly for the urban context. Article 243U sets a fixed 5-year term for municipalities, just like panchayats, with similar provisions for dissolution and timely re-election. One specific addition here is that a municipality must be given a reasonable opportunity of being heard before it is dissolved, providing a crucial procedural safeguard against arbitrary dissolution. Article 243V deals with disqualifications, again setting the minimum age for membership at 21 years. Then, Article 243W endows municipalities, and where they exist, wards committees, with powers and responsibilities to function as institutions of self-government. This includes preparing plans for economic development and social justice and implementing schemes related to them. Specifically, it refers to matters listed in the 12th schedule of the Constitution.
The 12th schedule analogous to the 11th for panchayats. What kinds of urban issues does that cover?
It covers 18 items crucial for urban life. Urban planning, including town planning, regulation of land use and construction of buildings, planning for economic and social development, roads and bridges, water supply for domestic, industrial, and commercial purposes, public health, sanitation conservancy, and solid waste management, fire services, urban forestry, protection of the environment, and promotion of ecological aspects, slum improvement and upgradation, urban poverty alleviation, provision of urban amenities like parks, gardens, playgrounds, promotion of cultural, educational, and aesthetic aspects, burials and burial grounds, cremations, cattle pounds, public amenities including street lighting, parking lots, bus stops, regulation of slaughterhouses and tanneries, a comprehensive list for urban management. For finances, Article 243X mirrors the panchayat provisions, authorizing state legislatures to empower municipalities to levy taxes, assign state taxes, provide grants and aid, and constitute municipal funds.
And critically, Article 243Y states that the very same State Finance Commission, constituted under Article 243I for panchayats, will also review the financial position of the municipalities and make similar recommendations for them.
So one finance commission covers both rural and urban local bodies. That makes sense for coordination.
Exactly. It ensures consistency and efficiency in reviewing local body finances across the state. Article 243Z provides for the audit of municipal accounts, ensuring financial accountability. And Article 243ZA assigns the responsibility for conducting elections to municipalities to the same state election commission established under Article 243K for panchayats, further streamlining electoral processes and ensuring independence.
Okay, so far it's a remarkably parallel structure, but cities and districts often have both urban and rural areas. How does the Constitution ensure integrated planning between panchayats and municipalities?
This is where Part XA introduces some truly innovative mechanisms for integrated planning, going beyond just empowering individual local bodies. Article 243Z mandates the constitution of a district planning committee, DPC, in every state at the district level. Its purpose is revolutionary: to consolidate the plans prepared by both the panchayats and the municipalities within that district, and then to prepare a draft development plan for the district as a whole.
A plan for the whole district, bringing rural and urban together. How is this DPC composed?
The composition is designed to ensure representation from both. Not less than 4/5 of the total members of the DPC must be elected by and from amongst the elected members of the district-level panchayat and the municipalities in the district. The representation must be proportionate to the ratio between the rural and urban populations in the district. The state legislature determines the specific functions and manner of election.
That is huge. It's not just about these local bodies existing in isolation, but actually forcing them to coordinate and plan development across the entire district, bridging the rural-urban divide.
It truly emphasizes integrated planning and resource sharing, moving beyond potentially siloed local governance. It's a constitutional push towards holistic district development. And it goes further for large urban agglomerations. Article 243ZE mandates the constitution of a Metropolitan Planning Committee, MPC, in every metropolitan area. Remember, 10 lakh plus population. The MPC's purpose is similar, to prepare a draft development plan for the metropolitan area as a whole. Its composition also ensures representation from urban and surrounding rural bodies within the metro area. Not less than 2/3 of the MPC members must be elected by and from amongst the elected members of the municipalities and the chairpersons of the panchayats located within the metropolitan area, again proportionate to their respective populations. The MPC plan must consider overall state and national objectives, spatial planning, infrastructure integration, and environmental conservation.
So specific planning bodies for districts and even larger metro areas, constitutionally mandated to ensure coordinated development. That's really thinking ahead about managing growth.
It absolutely is. It reflects a sophisticated understanding of the need for integrated planning in a rapidly urbanizing country. The remaining articles, 240ZF and 243ZG, deal with the continuance of existing laws and the bar to court interference in electoral matters, respectively, mirroring the panchayat provisions we already discussed.
That's a truly comprehensive look at how local governance, both rural and urban, is not just mentioned but deeply embedded and empowered within the Constitution. The level of detail from judicial independence right down to district and metropolitan planning is quite remarkable. Now, let's turn to what is often a fascinating and sometimes quite contentious area, how the union government and the state governments interact, especially when it comes to making laws. This is where the push and pull of India's federalism really comes alive, isn't it?
It certainly is. This is where the rubber meets the road for India's federal structure. Part X or 11 of the Constitution, particularly its Chapter 1 on legislative relations, details the distribution of lawmaking powers. It also sets out mechanisms for cooperation and, inevitably, for resolving conflicts when they arise. But before we dive into the general distribution of legislative powers between the union and states, let's quickly touch upon a specific type of area that gets unique constitutional treatment: scheduled and tribal areas.
Right, you mentioned those earlier. Part X, Articles 244 and 244A. What are these special provisions and why are they necessary?
These areas, predominantly inhabited by tribal communities, have special constitutional protections and distinct administrative mechanisms. This is due to their unique cultural identities, historical contexts, and often their vulnerability to exploitation. The aim is to protect their customary laws, land rights, resources, and allow for a degree of self-governance that respects their traditions while promoting their development. Article 244 is the main provision here. It provides for this special administration. Clause 1 states that the provisions of the Fifth Schedule shall apply to the administration and control of scheduled areas and scheduled tribes in any state other than Assam, Meghalaya, Tripura, and Mizoram. Clause 2 then mandates that the provisions of the Sixth Schedule shall apply to the administration of the tribal areas in the states of Assam, Meghalaya, Tripura, and Mizoram.
So, two different schedules, Fifth and Sixth, providing tailored administrative frameworks for different sets of tribal areas.
Exactly. The Fifth Schedule typically involves the formation of tribes' advisory councils and gives the governor special powers regarding land and regulation. The Sixth Schedule is even more elaborate, providing for the creation of autonomous district councils and autonomous regional councils with significant legislative, executive, administrative, and even judicial powers within their designated areas. It grants a much higher degree of autonomy.
And then there's Article 244A, which sounded really unique when we outlined it, an autonomous state within an existing state. That seems like an extreme example of federal flexibility, almost nesting dolls of governance.
It absolutely is an exceptional provision. It applies specifically to Assam and demonstrates the incredible flexibility built into India's federalism to accommodate very specific regional and ethnic aspirations. Article 244A allows Parliament by law to form an autonomous state comprising certain tribal areas within Assam. And for this autonomous state, it can create either a local legislature or a council of ministers or both with defined powers and functions. Parliament can specify the powers legislative and executive for this body, which can even extend to subjects normally on the state list or concurrent list. It can also provide for financial assignments. Importantly, like the laws creating legislatures for UTs, a law made under Article 244A is not considered a constitutional amendment under Article 368, making its creation easier. However, there's a special safeguard. Any amendment to this law that changes the legislative or executive powers of the autonomous state requires a higher threshold in Parliament, a two-thirds majority of members present and voting. This provides an extra layer of protection for the autonomy granted.
That is a powerful example of the Constitution bending and adapting to very specific regional needs. Now, for the broader picture, how are lawmaking powers fundamentally divided between the Union, Parliament, and the states? Where do their legislative boundaries actually lie?
This is the absolute core of India's legislative federalism, detailed mainly in Part 11, Chapter 1. We start with Article 245, which defines the extent of laws made by Parliament and state legislatures. Its core concept is straightforward. It sets the territorial limits of lawmaking power. Parliament can make laws for the whole or any part of the territory of India. Its reach is nationwide. State legislatures, on the other hand, can make laws for the whole or any part of their respective state. Their power is generally confined within their state boundaries.
Okay, Parliament has that nationwide reach. But what about laws that might need to affect things or people outside India's physical borders? Can Parliament make laws that have effects abroad?
Yes, it can. That's where Clause 2 of Article 245 becomes critical. It explicitly states that no law made by Parliament shall be deemed invalid on the ground that it would have extraterritorial operation. This means Parliament's laws can apply outside India, provided there's some connection or nexus back to India.
Like taxing the global income of an Indian resident?
Exactly like that. Parliament's Income Tax Act applies to income earned anywhere in the world by Indian residents. This power is essential for India's sovereignty, allowing it to regulate its citizens, entities, and interests internationally. States, however, generally need a much clearer and more direct territorial nexus for their laws to legitimately affect things or activities happening beyond their borders. The connection must be real and relevant to the state. The courts have developed this doctrine as seen in cases like State of Bombay versus RMD Chamar-Bagwala, which dealt with a state law regulating prize competitions that had elements, like advertising, happening outside the state, but targeting people within it. The court found a sufficient nexus. So the principle is, if there's a strong enough link or connection between the state and the subject matter of the law, even if partly outside, the state law might be valid. But Parliament's power for extraterritorial reach is much broader.
Right, that clarifies the where. Now for the whats. Article 246, this is where the core division of subjects lies, isn't it? The famous 3 lists. This is what everyone learns about in school civics classes.
Absolutely. Article 246, read together with the 7th schedule of the Constitution, is the absolute blueprint for legislative competence. It's the master plan outlining who gets to make laws on what subjects. Its core concept is the clear delineation of legislative powers into 3 distinct lists. List 1 is the Union list. Parliament has exclusive power to make laws on matters enumerated here. These are generally subjects of national importance. Think defense, foreign affairs, atomic energy, currency, banking, railways, citizenship, census, major ports, airways. Roughly 100 items. Clause 1 explicitly gives Parliament paramount power here, stating it has power notwithstanding anything in the other clauses. States generally cannot legislate on these Union list items. List 3 is the concurrent list. Here, both Parliament and state legislatures can make laws. This is a shared domain for subjects where uniformity might be desirable but not essential, or where local variations might be needed. Examples include criminal law and procedure, civil procedure, marriage and divorce, contracts, bankruptcy, education, forests, trade unions, price control, electricity. About 52 items.
Shared territory. So what happens if both make laws on the same concurrent subject and they clash?
That's where Article 254 comes in, which we'll get to shortly. Generally, if there's a conflict, Parliament's law prevails. But there's nuance there. List 2 is the state list. Here, state legislatures normally have exclusive power to make laws. These are typically subjects of local or regional importance: public order, police, prisons, public health and sanitation, agriculture, land revenue, water supply, subject to union control over interstate rivers, local government, around 61 items. Clause 3 grants states this power, but it's framed as being subject to Clauses 1 and 2, meaning union and concurrent list powers can sometimes override it. And there's Clause 4, which specifically clarifies that Parliament has the power to make laws with respect to any matter for any part of India not included in a state, even if that matter's on the state list. This reinforces the centre's direct legislative control over union territories.
Okay, so union list Parliament exclusive, state list states generally exclusive, concurrent list shared sandbox, but Parliament usually wins in a fight. Seems clear enough on paper.
On paper, yes, a neat division of labor. But as you can imagine, life and law are rarely that neat. Interpreting which list a particular law falls under isn't always straightforward. Subjects can overlap, or a law primarily about one thing might incidentally touch upon another list.
So how do the courts handle those overlaps or ambiguities?
That's where judicial interpretation becomes crucial. Courts have developed several key principles or doctrines to navigate this. One is the doctrine of pith and substance. This means the court looks at the true nature, the essential character, or the pith and substance of the law, rather than just its surface appearance or incidental effects. If the core substance of the law falls within the competence of the legislature that made it, it won't be struck down just because it incidentally touches upon a matter in another list.
Looking at the real purpose, not just side effects.
Yeah, exactly. Another principle is harmonious construction. When entries in different lists seem to conflict, the court tries to interpret them in a way that gives effect to both as much as possible. They try to harmonize them rather than letting one completely invalidate the other unless the conflict is irreconcilable. The State of Bombay versus F.N. Bulsara case from 1951 is a classic example of pith and substance. The court examined a Bombay state prohibition law. While it certainly affected the import-export of liquor, a union subject, its pith and substance was found to be related to public health and regulating liquor within the state subjects. So the state law was largely upheld despite the incidental encroachment.
That makes perfect sense. The lists provide the map, but you need judges to interpret the terrain when the lines get blurry. Now, what if Parliament needs more courts or specialized tribunals specifically to handle cases arising from its own laws, particularly those on the union list?
The Constitution anticipates that need. Article 247 gives Parliament the explicit power to provide for the establishment of additional courts for the better administration of laws made by Parliament, or of any existing laws with respect to a matter enumerated in the union list. This power allows Parliament to create specialized bodies outside the regular judicial hierarchy if needed. Think about things like the National Green Tribunal, debt recovery tribunals, or various administrative tribunals set up under specific union laws. It's a pragmatic recognition that the regular courts might get overloaded, or that certain types of disputes arising from complex central legislation might benefit from specialized expertise or faster procedures. While not directly interpreting Article 247 itself, landmark cases like L. Chandra Kumar versus Union of India, 1997, discuss Parliament's broad power to create such adjudicatory bodies. However, that case also strongly reaffirmed that the power of judicial review by the High Court and the Supreme Court remains a basic feature of the Constitution and cannot be completely excluded, even by these specialized tribunals. This facilitates specialized justice delivery while preserving core judicial oversight.
This brings up a really fascinating, almost philosophical point about constitution making. What happens if a completely new issue emerges? Something may be driven by technology, think cryptocurrency regulation or the ethics of AI, or maybe even space colonization laws someday. Issues the original framers in the late 1940s couldn't possibly have foreseen, and which don't neatly fit into any of the existing items on the three lists. Who gets to make laws about that?
That's where Parliament's residuary powers come into play, outlined in Article 248. This is a very significant feature, revealing the strong centralizing tendency in India's federal structure. Article 248 states that Parliament has exclusive power to make any law with respect to any matter not enumerated in the concurrent list or state list. Clause 2 explicitly adds that this power includes the power to make any law imposing a tax not mentioned in either of those lists.
So anything not specifically given to the states or shared in the concurrent list automatically belongs to the sender.
Exactly. This provision ensures there's no legislative vacuum. No subject can fall into a constitutional black hole, where no legislature has the power to act simply because it was not back in 1950. It strongly centralizes legislative authority, which is a key characteristic distinguishing India's model from, say, the U.S. or Australia, where residuary powers typically lie with the states or provinces. In India, if it's not mentioned elsewhere, it defaults to Parliament. This power is also reflected in Entry 97 of the Union List itself.
The case of Union of India versus Harbhajan Singh Dhill in 1971 is a famous example. The Supreme Court upheld Parliament's power to legislate a wealth tax act, relying on these residuary powers, even though the tax incidentally touched upon agricultural land, which is normally a stateless subject. The court affirmed the plenitude of Parliament's residuary power.
Okay, so that covers the unforeseen. Now back to the state list. We know Parliament usually can't touch it directly. That's the core federal principle. But are there exceptions? What if there's a genuine nationwide issue or an emergency that requires central action, but the subject matter technically falls under the state list? Is the system flexible enough to handle that?
Yes, it is. The Constitution provides specific mechanisms for what you might call flexible federalism, allowing temporary central intervention in the state legislative field under certain exceptional circumstances. Article 249 is the first key example. Article 249 deals with the power of Parliament to legislate with respect to a matter in the state list in the national interest. Here's how it works. If the Council of States, the Rajya Sabha, which remember is the House representing the states themselves, declares by a resolution supported by not less than 2/3 of its members present and voting that it is necessary or expedient in the national interest for Parliament to make laws on a specific matter enumerated in the state list, then Parliament becomes empowered to legislate on that matter for the whole or any part of India.
Wow. So the Rajya Sabha, representing the states, has to agree by a supermajority that it's in the national interest for Parliament to step onto their turf, so to speak.
Precisely. It requires a significant consensus within the Council of States itself. And this power granted to Parliament is temporary. The Rajya Sabha resolution remains in force for a period not exceeding 1 year, though it can be renewed for further periods of 1 year at a time by subsequent resolutions passed in the same manner. Any law made by Parliament under this power ceases to have effect 6 months after the corresponding Rajya Sabha resolution expires.
So the states, through their collective voice in the Rajya Sabha, essentially permit or invite Parliament to step in on a state subject, but only for a limited time and only when there's a clearly identified, agreed-upon national interest. It sounds like a constitutional safety valve, allowing temporary centralization when needed, but initiated by the state's House.
That's a perfect description. A constitutional safety valve. It enables temporary central intervention on state subjects when an overriding national interest is perceived and explicitly endorsed by the Rajya Sabha. It's a unique blend, reflecting India's quasi-federal nature. Importantly, the state legislature doesn't lose its own power to legislate on that subject during this period. It just means that if the state law conflicts with the parliamentary law made under Article 249, the parliamentary law will prevail while it's in force. It demonstrates national interest as a ground for central intervention, but with a crucial state-level check built in via the Rajya Sabha's special majority requirement.
Okay, that's for national interest. What about during a full-blown national emergency? When the country faces a major crisis like war, external aggression, or armed rebellion, does Parliament get even broader powers over state subjects then?
Absolutely. The powers become much broader during an emergency. Article 250 explicitly covers this. Power of Parliament to legislate with respect to any matter in the state list if a proclamation of emergency is in operation. While a proclamation of emergency issued by the President under Article 352 is in operation, Article 250 automatically empowers Parliament to make laws on any matter in the state list for the whole or any part of India.
Any matter. So the entire state list effectively becomes concurrent during an emergency.
That's a good way to think about it. Parliament's legislative power becomes plenary over the state list subjects during the period the emergency proclamation is active. Similar to laws made under Article 249, laws made by Parliament under Article 250 during an emergency also have a limited lifespan. They cease to have effect 6 months after the proclamation of emergency has ceased to operate. This power is designed to equip the Union government with the overriding legislative authority needed to effectively manage national crises, ensuring swift and uniform action across the country if required. It temporarily transforms the federal structure into a much more unitary one. Again, like under Article 249, the state legislatures aren't deprived of their power to make laws on state subjects even during an emergency. But if their law conflicts with a parliamentary law made under Article 250, the parliamentary law will prevail. Cases like ADM Jabalpur versus Shivkant Shukla, 1976, though highly controversial for their rulings on fundamental rights during emergency, certainly illustrated the profound shift in power towards the Union that occurs when an emergency is declared.
Okay, so Parliament can step into the state list under Article 249, National Interests with Rajya Sabha approval, or Article 250 during an emergency. What happens if a state also makes a law on that same state list subject while Parliament is acting under either 249 or 250? You mentioned the parliamentary law prevails, but how exactly does that work? Who wins that legislative tug of war?
That's where Article 251 comes in. It provides the clear tiebreaker rule specifically for this scenario. Inconsistency between laws made by Parliament under Articles 249 and 250 and laws made by the legislatures of states. Its core concept is straightforward. If any provision of a law made by a state legislature is repugnant, meaning inconsistent with or in direct conflict with any provision of a law made by Parliament, which Parliament has power to make under Article 249 or Article 250, then the parliamentary law prevails. This applies whether the parliamentary law was passed before or after the state law. But here's the crucial nuance. The state law, to the extent of the repugnancy, becomes inoperative. It doesn't become void or permanently struck down.
Inoperative, not void. What's the difference there?
It means the state law is essentially put on hold or eclipsed by the overriding parliamentary law, but only for as long as the parliamentary law remains in effect. Once the parliamentary law, made under 249 or 250, ceases to have effect because the Rajya Sabha resolution expires or the emergency ends, the state law can automatically revive and become fully operative again, provided it hasn't been repealed by the state legislature in the meantime.
So the state law is temporarily overshadowed but can spring back to life later. That's a really clever way to handle these temporary central overrides without permanently wiping out state legislation.
Exactly. It illustrates a specific application of the doctrine of repugnancy in this context, and the underlying principle is similar to the doctrine of eclipse. It ensures parliamentary supremacy during these exceptional temporary periods, but respects the state's legislative competence by not rendering its laws permanently void. It's a temporary suspension of effect, not a permanent nullification.
Now, here's a different scenario, almost the opposite of conflict cooperation. Article 252 sounds surprising. It talks about states asking Parliament to legislate on a state subject for them. Why would states voluntarily give up some of their own exclusive legislative power?
This is Article 252. Power of Parliament to legislate for two or more states by consent and adoption of such legislation by any other state. And you're right, it might seem counterintuitive, but it's a prime example of cooperative federalism in action. It provides a mechanism for achieving uniformity on certain stateless matters when multiple states desire it, but without needing a full constitutional amendment to move the subject to the concurrent list. Here's the process. If the legislatures of two or more states pass resolutions deeming it desirable that Parliament should regulate a specific matter on the state list for them, then Parliament can pass an act regulating that matter accordingly.
So the initiative has to come from the states themselves.
Yes, at least two states need to initiate it by passing resolutions. Once Parliament enacts the law based on these resolutions, that law applies only to those states that pass the initial resolutions. However, any other state can later adopt that same parliamentary law by passing a resolution in its own legislature. This mechanism has been used for important legislation where nationwide uniformity on a state subject was felt necessary. Classic examples include the Wildlife Protection Act, 1972, and the Prize Competitions Act, 1955. These were enacted by Parliament based on resolutions passed by several states. A crucial point, though, is stated in Clause 2 of Article 252. Any act passed by Parliament under this provision can only be amended or repealed by a subsequent act of Parliament passed in the same manner. The state legislatures involved cannot amend or repeal it themselves.
So it's a voluntary surrender of legislative power by the states for that specific subject to achieve uniformity. But once surrendered to Parliament via this route, the control over that law, amendment or repeal, stays with Parliament. That's a powerful illustration of states choosing collective action, but with a binding outcome.
Precisely. It demonstrates voluntary surrender of legislative power by states for a common good, facilitating desired uniformity while preserving the state's autonomy in the initiation phase. It highlights the dynamic and cooperative potential within India's federal structure.
Okay, one more major area concerning Parliament's reach. What about international agreements? If India signs an international treaty or convention, can Parliament then make laws to implement it, even if the subject matter touches upon something normally in the state list?
Absolutely, and this power is very broad and clear. Article 253 deals with legislation for giving effect to international agreements. It starts with a powerful phrase, notwithstanding anything in the foregoing provisions of this chapter. That means it overrides the normal distribution of legislative powers laid out in Articles 245 and 246, including the three lists. Article 253 gives Parliament the power to make any law for the whole or any part of the territory of India for implementing any international treaty, agreement, convention, or any decision made at any international conference, association, or other body.
So even if the subject is, say, water or agriculture, which are normally state subjects, if India enters into an international treaty related to river management or agricultural standards, Parliament gets the power to make the necessary domestic laws to enforce that treaty.
Exactly. This power is plenary and essential for a sovereign nation to fulfill its international obligations effectively. It ensures that the federal division of powers within the country doesn't become an obstacle to participating in international affairs and honoring international commitments. It establishes clear parliamentary supremacy in the domain of international law implementation. This is how international legal norms and obligations can be formally incorporated or transformed into domestic law within India, even if they cut across the normal federal distribution of powers. Examples could include laws enacted to implement environmental protection treaties, like CITES or the Kyoto Protocol historically, intellectual property rights agreements, like TRIPS, or international labor standards conventions. Cases like Maganbhai Ishwarbhai Patel versus Union of India, 1969, discuss the need for parliamentary legislation to implement treaties if they affect the rights of citizens or require changes to existing domestic law. And Vishaka versus State of Rajasthan, 1997, while mainly about fundamental rights, notably referred to international conventions like CEDAW to inform its guidelines, and Article 253 provides the constitutional pathway for Parliament to legislate based on such international instruments. This demonstrates the supremacy of Parliament in the international domain and the doctrine of transformation incorporation of international law.
Right. Now let's circle back to that concurrent list, the shared sandbox. You mentioned Article 254 is key when laws made by Parliament and a state legislature on the same concurrent list subject actually clash. This seems like it would be the most common battleground for legislative conflicts, right? How does Article 254 resolve this?
It is indeed the primary article for resolving repugnancy, specifically in the concurrent list, and it provides the general rule along with a very important exception. Article 254 is titled Inconsistency between laws made by Parliament and laws made by the legislatures of states. Clause 1 lays down the general rule. If any provision of a law made by a state legislature is repugnant to any provision of a law made by Parliament which Parliament is competent to enact, or to any provision of an existing law, meaning a law made before the Constitution that continues to be applicable, with respect to one of the matters enumerated in the concurrent list, then, subject to the exception in Clause 2, the law made by Parliament prevails. This applies whether the parliamentary law was passed before or after the state law, and the state law, to the extent of the repugnancy, shall be void.
Void. Okay, so unlike under Article 251, where the state law just became inoperative, here in the concurrent list, a conflicting state law becomes void to the extent of the conflict. Parliament wins, state law loses out permanently on the conflicting part. That's the general rule. But you mentioned a crucial exception in Clause 2. What's that?
That's Clause 2, and it offers a vital mechanism for state autonomy and experimentation within the concurrent field. It states that where a law made by a state legislature on a concurrent list matter contains any provision repugnant to the provisions of an earlier law made by Parliament or an existing law on that matter, then the state law can still prevail in that state, if it has been reserved for the consideration of the President and has received his assent.
So if a state passes a law on a concurrent subject that conflicts with an older central law, they can send it up to the President. If the President gives assent, the state law is saved and operates within that state despite the conflict.
Exactly. This allows states to enact legislation tailored to their specific needs or circumstances, even if it deviates from an existing national framework on a concurrent subject, provided they secure the President's approval, which generally means approval from the union government. It allows for state-specific variations.
So the President's assent acts as a shield, protecting the state law from being automatically overridden by the earlier central law under Clause 1. That gives states a bit more flexibility. But does Parliament still have the absolute final say in the long run, even after a state law gets presidential assent? That sounds like a really dynamic, almost layered balance.
It absolutely is a dynamic balance. And yes, Parliament retained the ultimate legislative authority. This is ensured by the proviso to Clause 2. This proviso clearly states that nothing in Clause 2 shall prevent Parliament from enacting at any time any law with respect to the same matter, including a law adding to, amending, varying, or repealing the state law that had received presidential assent. So even if a state law prevails temporarily due to presidential assent, Parliament can always come back later and pass a new law on the same subject, which would then override the state law, including the assented one. Parliament always holds the legislative trump card in the concurrent field.
That is a sophisticated mechanism. It accommodates state initiatives with central approval, but ensures national uniformity or policy can ultimately prevail if Parliament chooses to assert its authority later.
Precisely. It tries to balance national interests and state autonomy, but ultimately tilts the scale towards Parliament in the concurrent sphere. Landmark cases like M. Karunanidhi Union of India, 1979, laid down important tests for determining when repugnancy actually exists, like direct conflict or Parliament intending to occupy the whole field. And Zavarpai Amidas v. State of Bombay, 1954, is a key case confirming Parliament's power under the proviso to override even those state laws that have received presidential assent. This firmly establishes the doctrine of repugnancy and federal supremacy within the concurrent list framework.
Okay, one final, slightly more procedural point related to making laws. Sometimes the Constitution requires a prior recommendation or sanction from the president or governor before a certain type of bill can even be introduced. What happens if, say, through an oversight, a bill is introduced without that required initial permission, but it goes through the legislative process and then the president or governor signs off on the final act? Is the whole law invalid because of that initial procedural mistake?
That's where Article 255 comes in, and it provides a very pragmatic solution. It's titled, Requirements as to Recommendations and Previous Sanctions to be Regarded as Matters of Procedure Only. This article acts as a fascinating curative provision. Its core concept is that the absence of a required prior recommendation or previous sanction from the president or governor for the introduction or passing of a bill or amendment will not invalidate the resulting act if the bill subsequently receives the assent of the president or the governor, whichever was required for the initial recommendation sanction.
So it basically says if the final approval from the top constitutional authority, president or governor, is given at the assent stage, then the lack of their approval at an earlier procedural stage, recommendation or sanction, is forgiven. It prioritizes the substance of the final approval over an earlier procedural step.
Essentially, yes. It's a pragmatic safeguard. It prevents laws that have been properly deliberated and passed by the legislature and ultimately approved by the constitutional head from being struck down purely on a technicality related to an initial procedural requirement. It ensures that substance prevails over form in this specific context. It applies to various constitutional requirements, like the governor's recommendation needed for introducing state financial bills, money bills, or the president's previous sanction required for bills affecting freedom of trade and commerce under Article 304. So if a state money bill was perhaps introduced without the governor's initial recommendation, but the governor later gives assent to the final act passed by the legislature, Article 255 cures that initial defect. The act remains valid. It embodies the legal spirit of factum veli quod fieri non debut. An act done is valid, although it should not have been done, in this specific procedural context. It's a clear example of emphasizing substance over form and acts as a doctrine of curability or a validating provision within the Constitution itself. It prevents good laws from being lost due to minor initial procedural missteps, provided the final substantive approval is secured.
What an absolutely incredible deep dive. We've really journeyed through some complex territory today. We navigated the intricate pathways of India's constitutional design, starting right down at the foundations, the independence of district courts, then moved up through the nuanced ways power is shared with union territories, the deep commitment to empowering local bodies like panchayats and municipalities, all the way to that often complex, dynamic legislative dance between the union and the states, exploring how powers are divided, shared, sometimes clashed over, and occasionally even temporarily overridden in the national interest or emergencies.
It really shows, doesn't it? These articles, they're far from just being dry, abstract legal texts. They reveal the dynamic genius, perhaps, of India's constitution. It's a system built not just on rigid rules, but also on remarkable flexibility and foresight. It has mechanisms designed to adapt to incredibly diverse regional needs, to respond to overriding national interests when required, and even to fulfill global commitments. We see how specific choices like Delhi's unique structure, or the powers given to the State Election Commission, or the different ways Parliament can legislate on state subjects create this living framework that's constantly being interpreted, applied, and sometimes debated.
It truly makes you appreciate the constant, delicate balancing act required to govern such a diverse federal nation effectively. You have to accommodate both national unity and coherence, but also respect and empower regional aspirations and local needs.
And these constitutional provisions, these structures and rules, they're constantly at play in our daily lives, shaping the political and administrative landscape, even if we don't always consciously connect the dots.
Absolutely. So, as you, our listener, go about your day, maybe consider this provocative thought. How does understanding these foundational rules, the mechanics of judicial appointments, the powers of local government, the intricate legislative lists and overrides, how does that change how you read the news? How does it illuminate the daily headlines we see about center-state relations, or debates about judicial independence, or even discussions around funding for local development projects in your own area? How might knowing these specific articles and the principles and tensions embedded within them change how you perceive political debates and policy decisions in India? Does it make you see the Constitution less as a static document from the past and more as a dynamic, constantly negotiated arena where power operates today? Thank you so much for joining us on this deep dive into the heart of India's constitutional architecture. We really hope you're leaving with a fresh perspective and a richer, perhaps more nuanced understanding of how our nation is truly governed from the ground up and the top down.
Until next time, keep digging deeper.